Yep. Okay. Go!
Will you hand me my screen box?
Now go.
Call the case of the people of the state of Michigan versus Linda Down. So state your appearances.
David, I bring on behalf of the town. All right.
Okay.
Here, we're back.
Okay. All right. Date time set for trial. Well, date. You ready to proceed?
People are ready to proceed. We have sequestered our witnesses. I move sequestration of any possible defense witnesses as well.
We only anticipate one, Your Honor, and this is the defendant.
All right. Very good. Opening statement.
Your Honor, with the consent of defense, people will waive opening.
No problem.
All right. Would you like to give an opening, waive, or reserve, Mr. Colson?
We'll reserve, Your Honor.
All right. Very good.
Or I'm sorry, we'll waive.
All right. You may call your first witness.
Chelsea Chapman.
State, spell your first and last name for the record, please.
Chelsea Benham, CHELSEATHENHAM.
All right. You may inquire.
Thank you. Good afternoon, ma'am. Address of 49. What is that address? Your home address? Who lives there?
Me, my mom, and my two children.
What are your children's names? What's Keaton's last name? How old is Keaton?
He's 11.
When's his birthday? What month?
April.
Are you aware of any mental health or behavioral health diagnoses that Keaton has? What are his diagnoses?
He has several diagnoses.
Right on the head of here.
Could you just speak up a little bit?
Yes, sorry. He has several diagnoses.
What are some of them?
He has autism spectrum disorder, post-traumatic stress disorder, anxiety, depression.
Do you and your family coordinate care for Keaton with community mental health?
Yes.
Now, I'm going to ask you about an incident that is alleged to have occurred on August 15th, 2023. Do you recall that date?
Yes.
Where were you on that date?
At my home.
Who else was there?
My daughter Giovanna, my mom, two people from CMH from the crisis team.
Your daughter Giovanna, how old is she?
She's 2.
She was 1 at the time?
That's correct.
All right. Now, how did the people from CMH's crisis team end up at your home?
I was on the phone with Keaton's support coordinator, and Keaton was having a hard time. He was very emotional that day, and she suggested that I call the crisis team. So I called the crisis team, and they offered to have someone come to the home to try to help him out.
Was this the first time you had asked the crisis team to come to your home to help with Keaton?
That is the first time that anyone from the crisis team has actually come to the home, yes. Usually they just help over the phone.
So this time they came to your home. Who came to your house on that date?
I was, I believe a social worker, a crisis worker, I think her name's Linda, and then, I think it's a peer support person, I think, if I remember correctly, and I think her name's Katie.
Do you see either of those two people in the courtroom today? You see Linda here in the courtroom. Can you tell me what she's sitting, where she's sitting and what she's wearing?
She's over to the left.
Your Honor, may the record reflect and was identified the defendant.
Was that objection? Record shall so reflect.
Can you describe how Keaton was behaving at that time on that date when the defendant came over?
He was very emotional that day. He had been crying a lot. He was making a lot of comments about his work. He was having some suicidal ideations and kind of crying a lot off and on throughout the day.
And you didn't directly see any assaults or alleged assaults between the defendant and Keaton, correct?
That's correct.
I'm going to pass the witness, if I may just have one moment, Your Honor.
Yes.
Pass the witness, thank you, Your Honor.
Cross-examination.
You said your son has been diagnosed with, among other things, autism and PTSD. Is that correct?
Yes.
How does that manifest itself?
Sorry, I get confused sometimes. Do you mean like, how does that like?
Well, on a day, right, on a day-to-day basis, I mean, how would somebody who was with him know that he had those conditions?
He likes his routines a certain way and can get very upset if things are not the same way or predictable.
So does he have a quick temper?
Sometimes.
And when he loses his temper, what does he do?
He usually hurts himself by punching himself in the head or hitting his head on the wall.
Does he ever throw things?
Not usually.
But sometimes.
Yes.
Was he prescribed medication?
Yes.
Do you know if he was taking his medication on this particular occasion?
Yes.
Okay. What was it that he was doing that day that caused you to make the phone call?
He was making threats towards himself, wanted to kill himself.
Anything else?
No.
He wasn't doing anything physically?
To himself.
And that's what caused you to make the call?
Correct.
Okay, now you said that you had called on prior occasions and the crisis team had never actually come. They just talked to you over the phone.
That is correct.
Okay, did you specifically request that they come on this occasion, or is that something that they chose to do?
That was something I chose.
Okay, you didn't ask them to come?
So I think it's called the supports coordinator. She suggested that they come.
And you agreed?
Yes.
Okay, and was that because his behavior on that occasion was even beyond his normal behavior?
Yes.
Nothing further, Your Honor.
All right, thank you. Any redirect?
No, Your Honor, may this witness be excused?
Yes.
No objection, Your Honor.
All right. You may step down. Thank you, ma'am. Witness is excused. Let me call your next one.
Victoria Benham.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Are you familiar with Chelsea Benham? How do you know her?
Okay. Ma'am, I'm going to have to ask that you speak up a little bit if you could. Okay? Thank you.
That's a good volume for me. Is that a good volume for you, Mr. Goldstein? Great. And who's Keaton to you?
He is my grandson.
Do you live with Chelsea and Keaton on Pitch Pine Lane in Pittsfield Township? Do you recall being there on August 15th, 2023?
Yes.
On that date, who was in the home?
Chelsea, Giovanna, Keaton, a CMH, crisis worker, and a peer support person.
Do you see the CMH worker in the courtroom today? Could you please tell me where that person is sitting and what they're wearing?
She's wearing a brown sweater.
Your Honor. I'm sorry.
I can hear the answer, but just barely.
Okay. You got to try to keep your voice up. I know times.
Terribly sorry. I have cancer and
Oh,
I'm
I'm sorry.
talking as loud.
Loud as you can. Okay. Let's, you're right near the microphone. All right. Then it's okay. Yeah. If you move up and gotcha. Okay. So if they ask you to repeat, that's why. Okay.
And if you need a break, ma'am, we'll take, just let us know.
Okay.
Okay. When you got there, you said the defendant was already there?
Yeah.
Okay. And what did you see when you arrived?
My daughter was, and I asked her what was going on. She will come to help de-escalate the situation. But there was a lot of chaos.
What sorts of things was the defendant doing with Keaton that you saw?
When I got there, talking to him and trying to get him to sort of in place.
Your Honor, I heard her say something of talking to him and then she dropped her voice.
And I think you said trying to get him to stay in
One
place.
Trying to get Keaton to stay in one.
Yeah, he was very agitated.
What happened next?
She had picked Keaton up and put him into a chair and slapped him on the leg and told him, I believe, to settle down.
Did she say anything else?
He said to not talk to me. At that point, I asked Chelsea to call 911.
Now, when you saw the defendant slap Keaton on the leg, was her hand open or was her hand closed? What part of his leg did she slap?
The calf.
The calf, the lower part of the leg?
Yes.
Was this during the meltdown?
Yes.
What was Keaton doing during the meltdown?
He really, aside from being agitated, I think he was definitely overwhelmed and overstimulated. And so many people talking at one time. I do remember him on the floor and screaming. I believe that he did say some obscene words to her and to me.
Okay. Did you hear the defendant say anything to the other CMH worker who was there?
Yes,
At one point, did you try to hold Keaton down and restrain him?
I did.
Why did you do that?
I was trying to bring Keaton back in. We have been trained to bear hug Keaton, but that wasn't an option, given where he was at. So, I was trying to get him to look into my eyes so we could work on some deep breathing and focusing. And starting to get him to calm down, but she came and grabbed him by the arm and pulled him up.
Did that time where you were trying to get him to breathe and calm down happen before or after you saw the defendant slap Keaton?
Before.
So you're trying to get Keaton to have breathing exercise and calm down. And then the defendant took him from you?
Yes.
And then did the slap happen immediately after that, or was that sometime later?
No, I would say it was about 5 minutes later.
Okay.
I'll pass the witness, Your Honor.
Cross-examination.
If I heard you correctly, you said that the workers were there when you arrived.
Yeah.
And so obviously you don't know what happened before you got there.
Correct.
You don't know how they came to be there.
My daughter had said she called.
Okay. How many times prior to that occasion did workers from CMH come to your house?
I believe twice.
How many times did they come to your house because either you or your daughter called them and asked them to come?
I believe twice. Correct.
Okay. So you think on at least 2 other occasions, they came because they were called as opposed to just stopping in to seeing how people were doing. Is that a fair statement? Okay. Obviously, when you got there, you didn't know what Keaton had been doing or why they were there. Is that correct? Is that a fair statement?
No, my daughter had called me in the car prior to me. I didn't know.
Okay. And she told you there was a problem. I don't want to go into detail because of what she told you, but basically she told you there was a problem and that's one of the reasons you hurried home. Is that a fair statement?
Correct.
Okay. And she told you she had to call CMH for help because of Keaton's behavior. Is that also a fair statement?
Yes.
Okay. And when you got there, you described it, your words on the stand were he was having a meltdown.
Yes.
And you described also at various times that he was kicking and screaming and he was rolling around on the floor.
Yes.
Okay. And you also said that he was saying some obscene things. Who was he saying them to?
Everyone in the car.
What was he saying?
Remember.
That's fine. I mean, I don't want verbatim if you can't. Just when in general, I mean, for example, were they threats? Were they racial comments?
No.
Cuss words. Now, you described a moment ago that at some point, Miss Donald put him in a chair. Is that correct? And he said something about not hitting, she said something to him about not hitting people or not trying to hit her or something of that nature? Okay. So that suggests to you that before she did that, he had been trying to hit her. Is that a fair statement?
Objection, speculation.
It's her, she's there, Your Honor, it's her perspective.
I did not see him hit.
Okay, that wasn't my question. When somebody says to an autistic child who's having a meltdown, don't hit, would that suggest that he might have been trying to hit somebody?
Yes.
Okay. And has he, in the past, when he's had, I don't want to say the same meltdown, but at least similar meltdowns, have you seen him throw things?
Yes.
Did you see him throw anything that day?
I do not remember him throwing anything.
Now, you say she took him by the arm or by the hand and put him in a chair, is that right? And put him in a chair. So grabbing onto his hands. Arms, yeah. Okay, fair enough. Did she physically restrain him in the chair or did she just put him in the chair?
Yes, she did that.
Okay. And was she holding on to him?
Yes.
Like this, with his hands like this?
I remember his arms.
Okay, so you don't remember how she was restraining him, but she was restraining him.
She was clean.
And telling him not to hit. Now, did you actually see her slap him on the lower thigh or did you just hear it?
It was his cat, and yes, I saw it.
Okay. How many times? Okay. And what was he doing when she did that? Okay. Could you see what he was doing with his feet?
Not she was.
Okay. So you don't know, for example, whether he was trying to kick her since she was over him and holding him down. You don't know whether he was using his feet to try to kick her.
Correct.
Did you ever, and I say you, meaning all of you collectively, did you ever get him calmed down?
He was transported to the hospital.
Whose decision was that? Okay, so it wasn't Linda or Katie. Okay. So you, I think, said you called the police or Victoria?
I had Chelsea call
I'm
it.
sorry, Victoria, Chelsea, sorry. And they made the decision to transport him to the hospital.
Yeah.
And that wasn't your suggestion. That wasn't your daughter's suggestion. That was the police side.
Yeah.
What hospital?
When she put on I don't know for how long.
Do you know what unit he was hospitalized in?
Specialized autism psychiatric ward.
Okay, so you're not telling us you don't want the court to believe then that he was somehow physically injured during this incident and had to be taken to the hospital for medical treatment.
No, he was taken for trauma.
Okay. Nothing further, Your Honor.
All right. Any redirect?
Your Honor, may this witness be excused?
Yes. Ma'am, you're excused. Thank you.
Kathleen Carroll.
All right.
Kathleen Carroll, first name Kathlleen, last name Carrll.
You may inquire.
Good afternoon, ma'am. How are you employed? How are you employed?
I work for Downtown full time.
And in August of 2023, how are you employed then?
I worked full time as a peer support specialist with Community.
Is that here in Washtenaw County? Did you respond out to a call involving a young man named Keaton in Pittsfield Township in August of 2023?
Yes.
Who went with you, if anyone? Do you see the person you know to be Linda Donald in the courtroom today? Could you tell me what she's wearing and where she is sitting?
She is sitting at that table, in a cardigan with a mask on.
Your Honor, may the record reflect was identify the defendant.
Without objection, record shall so reflect.
Thank you. Ms. Carroll, I'm going to skip ahead a little bit to after you had arrived at the location where Keaton Bowlby was present. Do you recall that? Can you tell me, how was Keaton's behavior when you arrived at the home?
Keaton's behavior was fairly escalated. He was yelling, not really able to regulate his emotions. He was pretty aggressive. Sounded like he had been aggressing toward mom and grandma before we arrived. And when we arrived, he was verbally and physically aggressive towards myself and Linda.
What was your role at that time insofar as being, I think you described it as a peer support specialist?
Yeah, so my role specifically, I worked with kids through the crisis team for 2 months. So my job was to be the person with lived experience, mental health issues, and relate to clients and sort of play that part in crisis intervention calls.
Do you know what Linda's role was on the crisis intervention team?
I believe she was, I don't remember their title, but she was a clinician.
And what is a clinician's general role on the crisis team?
To be a social worker, essentially provide a higher level of intervention than I could. I believe all of our clinicians were social workers.
When you arrived at the home and you observed Keaton behaving as you described earlier, did anyone take over, or did you both have separate jobs that you did?
We sort of interacted with Keaton together in tandem.
What were some of the things that you did with Keaton?
I sat with Keaton and tried to redirect his attention away from the sort of big anger he was feeling in that moment, and I remember encouraging him to take big, deep breaths into his stomach, using like blow it up like a balloon, and talking to him about, what does anger feel like in different parts of your body, and what can you do instead of becoming violent or yelling when that comes.
Did the defendant interact with Keaton at all?
Yes.
What were her interactions with him as far as you recall?
I don't recall too many of them specifically. I recall her also asking the questions sort of like at the same time that I was, but I'm not going to lie, I don't recall the specifics of this moment.
Okay. Do you recall yourself ever having a physical interaction with Keaton?
No.
Do you recall ever taking anything away from Keaton?
There was a moment where Keaton was sort of poised with, I don't remember what type of bottle it was, but it was made of glass, and he was holding it above his head, sort of like this. And this was towards the very end of the interaction. He was pretty escalated at that point. And he was sort of poised to throw the bottle at his little sister, if I remember correctly, was about a year old at the time. And I was standing between his little sister and Keaton and put my hand on the bottle to stop him from throwing it toward the baby.
You made a motion a few moments ago that I want to document for the record because we have a recording. We don't have a video recording necessarily. So I want to describe what I think I saw. You tell me if it's correct at the end. You took your hands, you made a fist with one hand, and you kind of clasped your other hand over the fist and raised those two hands above your head. So your elbows were about eye level. Is that correct?
Yes.
Okay. That's how he was holding the bottle?
Yes.
Did you see the defendant have any physical contact with Keaton?
I did. I believe I described it in a police report into the Office of Disciplinary Rights shortly after the incident. But I remember seeing the defendant sort of hold Keaton in place and Keaton began to try to kick the defendant, and the defendant slapped him one time with an open palm on his lower leg.
Did she say anything when she slapped him?
I do not know.
Do you recall her making any statements? What do you recall her saying?
I recall statements being made to the effect of, I'm willing to lose my job, I'm not afraid to lose my job today. Things of that nature.
Now, when this slap happened, can you tell me about where it was on the leg?
Yeah, it was just above his ankle bone, based on the.
How close were you to the two of them when that happened?
I would say I'm not so good at number
Sure.
measurements, but I would say I'm as close as I am to you right now.
Were you able to hear the slap? How loud was it?
It was demonstrate by clapping. I don't know how to.
Let me just ask a different question. Was it audible?
Yes.
What happened after that?
Do you not recall the exact sequence of events that happened after that?
Okay. At some point, did you leave that location?
Yes.
Where did you go?
We went back to the CMH location at 750 Tower AMC.
How did you get there?
We drove.
And were you in one car or two cars? Whose car were you in?
The defendants.
Was it her personal vehicle or a state vehicle?
Personal.
Did you have any conversations on the drive back?
Yes.
What did she say to you?
Based on what I recall, I remember her asking me a few times if I believed and agreed with her that she had acted in self-defense, and asking a couple of leading questions to the effect of, we don't need to mention this to anyone, right? Nothing went wrong here, right?
How did that make you feel?
It was, it was a long day with the situation in general, not just limited to the incident that you're asking me about. The entire day was pretty uncomfortable.
Did that interaction also feel uncomfortable? Do you recall if that was the only time that you saw the defendant touch Keaton during this interaction?
I believe so.
Do you recall if when that happened, the incident with the slap on the leg, how the defendant was touching Keaton?
I can't say today that I recall the spatial position of things, but I remember her having held his arms because he was trying to hit people and was aggressive.
Okay. Here, and I'll pass the witness.
Cross-examination.
Is it okay if I call you Katie?
Yeah, that's fine.
Katie, if I understood you correctly, when you and Linda got there, both grandma and mother were there?
Yes.
Okay. I'm going to use maybe a technical term. You were dispatched to that location. Is that a fair statement?
That is a fair statement.
What briefing did you get as to what was going on before you got there?
I do not recall.
Okay. Do you know if Linda got any kind of briefing?
I do not know.
Okay. Would it be a fair statement, Katie? And I'm not trying to put words in your mouth, but would it be a fair statement to say that you had no idea what you were walking into?
Yes.
Okay. And what you were walking into was an autistic 10-year-old. And by the way, just give me a brief description of him. Was he unusually large, unusually small? Was he physically disabled in any way?
He was he had a pretty significant stature for a 10-year-old from what I remember. He was not physically disabled in any way, whatever.
Okay. So you walk in and he's having, as you heard, well, you didn't hear, sorry. So you're walking in and he's having what somebody else described as a meltdown. Okay. And I'm just trying to sort of compress things. he was kicking, he was trying to hit people, he was screaming. And the two of you, you and Linda, did your best to try to get a hold of the situation. Is that a fair statement?
Yes.
And the only physical contact that you can recall between Linda and Keaton was at some point Linda took him by the arms?
I believe so, but it does happen already.
No, I understand. Based on your what you can recall right now. Okay, when you and I were talking before court, you actually put your hands up and held them up together like that. Is that what you recall? Okay. And while she was doing that, he was trying to kick her. Best view you had? Okay. And that was the time when you heard her slapping his, okay. Do you recall her saying anything while that was happening?
I do.
Okay. So you don't recall her saying anything like, don't do that, or don't hit, or that's not appropriate, or anything like that?
I do not.
Okay. Katie, when you and I were talking earlier, you told me that you thought there were times when he was acting in a very aggressive manner. Is that a fair statement?
Yes.
Physically aggressive?
Yes.
Okay. And also verbally, correct?
Yes.
Okay. Was any of that directed at you, or was it all directed at Linda?
There was some directed at me, but I would say that it's fair to say more of it's directed at.
And I think you even told me that you at no point felt physically threatened, but you couldn't speak for Linda, correct?
Yes.
Okay. Do you recall anything that Keaton was saying while all this was going on?
I do not.
Okay, so you don't recall if he was making verbal threats or making obscene comments or racial comments or anything like that?
I don't recall the exact content, but I do recall him making some pretty, at the very least, insulting comments. The definition of obscenity is pretty vague, but I would say racial and potentially threatening would be accurate, yeah.
Okay, and directed primarily, not only, but primarily at Linda.
Yes.
Nothing further, Your Honor.
Any redirect?
No, Your Honor, thank you. May this witness be excused?
Yes, ma'am, you may step down. Thank you. Any additional witnesses for the people?
No, Your Honor, you can rest.
Your Honor, at this time, I have a motion for
Go
a
ahead.
directed verdict of not guilty.
Yes, sir.
Even in the light taken most favorable to the people, we have two CMH workers coming to a location, called there because you have an autistic, PTSD suffering individual, fairly large, I mean, 10 years old, I acknowledge, but fairly substantial stature was, I think, Katie's words, who is out of control. He was kicking, screaming, trying to hit people. And my client used only enough force to try to control the situation. What I suspect is the crux of the charge is slap on the leg. And that slap on the leg came based upon the testimony of two of the witnesses of the people when my client was trying to physically calm him down and he tried to kick her. So she slaps him on the leg. That is not abuse. That's not even an assault. When she's doing that in response to an aggressive action on the part of that individual. Now, I recognize he's 10 years old, but still, everybody that testified that he was out of control and he was physically threatening. So the people have not sustained their burden of showing the charge in this case.
Response.
And I'd ask the court to deny the motion for a directed verdict and to go forward with hearing argument and making this decision based on the proofs. And in this case, self-defense, of course, as the court knows, is a question of fact. The witnesses so far have testified that the defendant was the one who engaged in the physical contact. She was the one holding him down and that she slapped him. There is evidence to support a finding of guilt in the light of the evidence viewed most favorable to the prosecution. We'd ask the court allow the trial to continue and make its decision based on the facts after hearing argument, closing arguments, and if there is any defense testimony, of course. We ask that the court just allow the trial to continue.
Well, but would your argument be the same, even if it wasn't an issue of self-defense? But if one is looking at what one has to determine the defendant's intent, and would that sustain, looked at most favorably to the people in an assault charge?
I'm not sure I understand the court's question, so.
If I look at all of the evidence, the light most favorable to the people, is the intent element satisfied?
People believe it has been satisfied based on the defendant's actions and her statements of, I don't care if I lose my job today, I don't care, and continuing and then going and physically slapping a child's leg when she's already engaged in trying to have physical control over it.
Judge, I don't want to jump in, directed your question to Ms. Blondie, but let me point out the fact that that was the reason why Ms. Donald was there. She was called there by the family because this kid was out of control. It was her job to, along with Katie, to try to get the situation under control. And when she's holding this individual and the individual is trying to kick her, for her to slap his foot away, I mean, the court characterized it as self-defense, and I think I may have used that word, but I think more than that is that her behavior was justified, that was why she was there, to prevent him. And I say that in the context of Katie's testimony, that most of the aggression on this kid was directed at Ms. Donald.
Your Honor, there's no evidence in the record at this point to support that physically restraining the child was part of the crisis team's response. That was
what?
Was part of what the crisis team was there to respond to do. It was not to physically restrain the crowd. There's no evidence in the record to support that was part of the application. There's no, at this point in the record, the people have presented evidence they were there to help assess the child.
Your Honor, the burden's on the people.
Yeah, I mean, this is backwards at this point. I mean, is there any, wouldn't the burden be on the people to show, given the circumstances, that somehow she acted outside of the scope of what she was supposed to do?
When I was questioning Ms. Carroll, the other witness, she indicated that she had no physical interactions with Keaton except to take one bottle away from his hands. There was no indication that she had any physical contact with him. She didn't restrain him. She didn't touch him. She didn't sit on him.
She also testified that the physical aggression was aimed at the defendant.
Not solely.
But, okay, let me just try to get this right. Is it the people's position that the crisis intervention workers would have no authority to make physical contact with Keaton?
No authority to make physical contact with Keaton?
Yes.
In this circumstance, it doesn't appear that it would be appropriate for them to make physical contact with.
Where do I get that from?
The parent and grandmother were there and present and able to physically restrain. That's the argument.
Pardon?
The mother and the grandmother were there and they could physically restrain. The people's position is that it's not appropriate for a CMH worker to slap a child.
Where do I get that from, though? Where do I get that the physical restraint would not be an appropriate response from the CMH worker? Where am I supposed to get that from?
Your Honor, when Ms. Carroll was testifying, she talked about how she did not have any physical interactions.
But the fact that she did not doesn't mean that you can't. I mean, what you're arguing, first of all, Ms. Carroll and the defendant are there in different roles.
Yes.
That was very clear by her testimony.
Yes.
So someone in the defendant's role, where do I have evidence that she exceeded some authority or action?
The exceeding of authority, the assaultive conduct is not necessarily the restraint. People are alleging a slap is where it becomes a criminal action. That is the point at which it's become a criminal.
But I have an individual, by testimony of other witnesses, kicking And then Miss Carroll's specific testimony was that she believed that Keaton was trying to kick her at the time of the slap.
And Your Honor, then we also, the court asked about intent as well. Correct?
Well, yeah, but I haven't left this subject yet.
Okay.
Because what's being argued is that somehow the defendant exceeded her authority. I'm not sure where I get that from based upon what I heard. But even if, and the people aren't arguing that the defendant could not have restrained him.
Correct.
And then the only testimony, because one of the witnesses testified she could not see what Keaton was doing at the time of the slap or right before the slap on the calf.
Ms. Victoria, yes, Your Honor.
Ms. Carroll, however, specifically stated that when the slap happened, she believes that Keaton was trying to kick her, her being the defendant.
Yes, Your Honor, that is what she testified to. The people are not arguing that the defendant had zero right to physically intervene. People's argument is that the slap was set too far, and that's why we're asking the court to deny the motion for the directed verdict and allow the trial to continue to a verdict.
How does the people's theory that it's a step too far, was she supposed, if someone was trying to kick her, Keaton, is she supposed to let that happen? Or are the people arguing that that technique, as opposed to grabbing and restraining his leg, is what makes this different?
Yes, Your Honor, the latter.
So she should have grabbed and restrained his leg rather than a slap to the leg of "don't do that."
If I was to advise action,
Okay, let's assume that, and I get what the people's argument is. Where do I get that either of those would be appropriate, or that either would be inappropriate, or where do I have anything that draws a distinction between the two?
the touching done by the defendant to restrain Keaton from hurting others or hurting himself was done in the sense of stopping that from happening. The slap is where it becomes harmful, offensive, or violent touching. The touching in a slap to the leg of the autistic child having a meltdown is very different than a restraint of him stopping him from hurting himself or stopping him from hurting others. Her behavior after the incident, when she's speaking with Ms. Carroll about what happened, and the evidence before the court of her not wanting to discuss the incident, of her not.
I'm at a loss, Ms. Lundy. I'm at a loss to figure out if she grabbed his leg as opposed to slapping his leg, what becomes the distinction in that as to whether or not one constitutes an assault and the other does not?
The viewpoint of the people would be grabbing the leg to immobilize him to stop him from causing harm is in line with the other types of touching that happen today. It's in line with the types of touching that prevent Keaton from hurting himself or hurting others. Slapping his leg does not immobilize his leg, does not stop him from kicking.
Yes, it does.
Now, there was a characterization by defense counsel during his motion that defense put away. That's not what that's not what was testified to. It was that it was a slap on the leg. It's not slapping the leg away.
You say potato, I say potato. I mean, what's the difference, Judge?
I'm a bit unclear as to what the people are arguing that the slap to the leg was in some way to place Keaton in fear or harm him in some way?
That it would be a violent, forceful, harmful, sort of touching for the purposes of the assault and battery statute.
Trying to figure out where I get that from, because and that's where I go to the intent. If her intent were to do that, then I might agree with the people. My concern is all of the testimony I have indicates that her intent was to stop him from kicking. That's different than if she is just attempting to try to cause some offensive touching to the individual. Unless I've got it wrong here, that there's some other strike to the child for some other purpose.
Evidence already to this point that the defendant was engaging in physical contact with Keaton to restrain him. The people's contention is that if she had wanted him to restrain him from kicking her, she didn't slap him on the leg. She could have simply gotten control of his leg and held on to it like she was holding on to his hands.
So he's on the floor as the testimony.
Maybe in the chair.
Well, no, hold on. Initially, he's on the floor.
Yes.
According to Victoria, the defendant picks him up by his arms and puts him in a chair. The people are not arguing that's an assault.
Correct.
The restraining, and I think where they indicated also that she had part of her body and she's restraining him to the chair. That also the people are not arguing is an assault.
That's correct, Connor.
That then while she's restraining this individual in the fashion that she's restraining him, the testimony I have is that believes that Keaton was trying to kick her. So something is going on with his lower body at that point. That was, by the way, the testimony also is it was going on the floor when he was kicking. That her attempt to potentially stop that in that fashion would, in people's mind, then constitute an assault.
Yes, Connor.
Anything else from our side? Court's going to stand in very brief recess. I'll come back and give my decision on the motion. Back on the record in the case of the People versus Donald. The defendant's motion for a directed verdict, given the standard at this time, but also acknowledging as to whether or not an individual could find beyond a reasonable doubt, or a fact finder could find beyond a reasonable doubt that the defendant committed the offense of assault and battery, but also acknowledging that I have to take the evidence in the light most favorable to the non-moving party. The court is at this time going to deny the defendant's motion for a directed verdict at this time.
Your Honor, we're going to rest.
All right. Closing argument.
Your Honor, I'll be brief as I largely previewed my closing argument for the court from the people during the directed verdict motion, which is that in this case, the defendant responding out to assist this family in a mental health crisis did not go too far when she arrived. She didn't go too far when she tried to talk to the child. She didn't go too far when she tried to stop the child from hitting others and hitting herself, but that she did go too far when she slapped the 10-year-old child on the leg. We ask the court return a verdict of guilty for assault and battery Thank you.
Thank you.
I will also be brief, Your Honor. And I thank Ms. Londy for narrowing scope of the argument to that one point. It's something I didn't say to the court when we were arguing the motion. Ms. Londy said, Your Honor, it's the slapping. It would have been okay had she grabbed his leg to keep him from kicking her, but not to slap the leg away or slap the leg. She objected when I used the word slap the leg away. Your Honor, take it out of the context of CMH worker and a 10-year-old kid. Somebody tries to kick another individual. That individual is not going to sit there and say, gee, what's an appropriate response? Is it okay if I grab the leg, but not okay if I slap the leg? No, that you don't have that luxury, Judge. She did what she did in an attempt to keep from being kicked. And on that basis alone, she should be found not guilty.
Your Honor, just in rebuttal closing, context is everything.
Yes, it is.
Whoa, stop,
I was just agreeing.
stop,
Oh, was that being?
Stop.
Oh, I was trying to,
stop.
sorry.
Go ahead, Ms. Londy.
Your context is everything. This is not a situation that happened down the street and someone tried to kick someone randomly. This is a situation where this child is having this mental health crisis, and this is the trained responder to come out. People contend it's not okay for him to be slapped by the worker that was supposed to be there to help him.
Court, looking at the entirety of this set of circumstances and listening very closely to the witnesses in terms of what was going on at that point, it is clear that Keaton is at an escalated point. That he does have, based upon the testimony, at times that he hits others, he's angry, he throws things, and that at this particular point he wanted to kill himself. The two workers arrive, scene, and as by the testimony, Keaton is on the floor. He's at one point, he's kicking, he has things in his hand that or some type of glass object or ball in his hands. The defendant in this case, this is from Victoria, indicates that she picked him up by his arms, put him in the chair, and that there was talk about how disrespectful she's being. So at the point in time, there is an attempt to de-escalate, is the best as the court could describe it, by putting him in a chair and restraining him in some fashion. That then at some point, and I think it's critical to realize that based upon the testimony, that when on the floor, he's described as he's just kicking. He's doing all kinds of things. She brings him up to the chair, restrains him. But what really one notices by the testimony is that what she's restraining at that moment, and what everybody testifies to, are his hands and his upper body. It is clear from at least the testimony and the way the court views it, that she doesn't have his lower body restrained. It then brings me to the testimony of Ms. Carroll, who indicates that she believes Keaton was trying to kick her. Say that again. She believes, because she's there looking at it, believes that Keaton was trying to kick her. Remember, the other witnesses are saying they can't see what Keaton's doing at that moment because of the way that the defendant is positioned. She then responds by slapping his leg just above the ankle bone. There's no testimony, slapped it, not that it would be necessary for an assault and battery, that in any way it caused an injury or hurt the child. But think when one looks at the entire context of it, she had to have some intent to commit an assault. I don't believe that was what her intent was. Her intent was to stop him from kicking at that moment. Mind you, at least in this court's mind, based upon what the court hears, for the protection of everyone that's there. That's why she's restraining. That's why she's doing everything she does so that others aren't hurt by what is an unfortunate episode on Keaton's behalf. Not only legally, but also in good conscience, given the circumstances. This court could not, by any stretch of the imagination, find that the defendant intended to commit an assault and battery, or that the actions of the defendant in restraining Keaton, because it's all one act in terms of what she's doing. You can't parse it apart and say that slap to the leg is an assault as opposed to the actual restraining. She's trying to do a certain thing. Some may agree with it, some may not. But this court does not believe that she was trying to commit any type of an assault and battery upon Keaton at that moment. She was trying to keep everyone else safe, stop him from hurting anybody. More importantly, she was probably trying to stop him from hurting himself. And so for those reasons, the court would find that the people have not sustained their burden and would find that the defendant is not guilty of this offense. The defendant is discharged from any further obligation.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Have a nice night.
Are you kidding me?
Oh, my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in front. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let's feel
I'm sitting up here, I'm the one that needs a drink.